Declared a mistrial. His retrial is scheduled for next year. His defense also was insanity. So what will the impact of the two surviving shooting victims in Terrence Huff's case be on this Ohio jury? Is it strong enough to overpower the defense's theory that this veteran firefighter just snapped the day he shot and killed 3 people? Let me bring my guests into the conversation, Joanna Greenwald and Seema Iyer. So ladies, how about it? This kind of victim impact testimony is very compelling. How will it play in this case? Joanna?
Well, I think victim impact testimony is actually very, very important. The problem that I saw from all of the cases you just brought on, because I actually discussed the Hawk case with you in the past, is that people have a really rough time understanding insanity defenses. So even when you have a victim who's saying everything that's right, and everybody understands it, and nothing sounds normal, even with all of that and this convincing testimony of how horrific this horror that occurred, they still have a rough time trying to put 2 and 2 together and what to do about it. So you could have the most compelling evidence, but they don't know what to do with an insanity. Or, for example, in the Hawk case, it was Washington v. Ferrick that established the lesser included defense of diminished capacity.
Yes.
And they didn't know what to do with it.
Which is not available in every jurisdiction.
Exactly.
And as you point out, for juries, any kind of mental health defense is difficult, whether it's a full-on insanity, diminished capacity, I just snapped, temporary insanity, all very difficult. And Seema Iyer made all the more so when you have survivors who testify about their horrors of the shooting spree. 3 people did not make it, and that is why Mr. Huff is on trial for murder. He says, though, that he just snapped. Now, let me bring my guests back into the conversation, Joanna Greenwald, Seema Iyer, and begin with the obvious question. Help us understand the I just snapped defense from a full-blown insanity defense. Seema?
I don't know where they're
talked about earlier, and of course Andrea Yates, perhaps the most notorious person who recently and successfully demonstrated insanity. But let me come to you, Joanna. I agree that you've got to have some experts anytime you have a mental health defense. But there is something working to this defendant's favor, and it is that he was a firefighter, and he is a man who saves lives, doesn't take lives, and he was trained in that way. And this is essentially out of character. That's got to help him on some level with the jury when he says, look, I was so wound up under so much stress given my work and my family situation that I, quote, just snapped.
I don't agree with you at all whatsoever. I'm sorry, but I don't agree with you at all whatsoever. The reason why I don't is that, again, people would have been sympathetic saying this person is someone who is a lifesaver. So the fact that he snapped, this is something that never should have happened, which makes it much, much worse. It's almost like how the mighty have fallen, and that he has fallen from grace in such a horrific way. And just to go back to your original question, when you were just asking about the snapping, is that people could become dissociative, and that's an argument with the temporary insanity defense that people have often, that all of a sudden they snap, they don't recall. It's almost like someone who's a drinker. They black out, literally. They don't know what they did, and they know something bad happened. They find out afterwards. The problem this case had, and what I've reviewed, is that they had 3 psychiatrists, 3, not 1, not 2, 3, who evaluated him, and nobody could corroborate, just like Seema has suggested. No one could corroborate that this guy, in fact, had a dissociative situation occur, which goes along with temporary insanity, that he had any history, and the fact that he's a fireman, where we haven't brought this in, where we often deal with post-traumatic stress that happens when you're a fireman, because you've seen such horrific things in your life. You see dead people, you see things that happen. None of this was brought in, because if you don't have the expert, you got nothing to talk about. So him saying he snapped does not help him at all. Rather, he looks so much worse because he's the one who's in charge of protecting us. And he hurt people.
Raises the obvious question of whether he needs to take the witness stand to explain what went on. We'll ask our guest that question in a moment. Right now, have to take a quick break. Don't go away. Up next, we'll have more coverage of this firefighter on trial for his life. And a little later on, we're going to head back to 131 victims, the same age group as 2 of the 5 shooting victims in this Ohio case. Well, let me bring my guests back into the conversation. Joanna Greenwald, Seema Iyer. It really obviously begs a question about the prevalence of firearms, but in this case, we're not talking about any sort of illegal handgun or really any question about someone who maybe had access to firearms and shouldn't have, as in the Hawk case that we discussed before. His mental illness should have precluded access, or La Calamita, same issue. Here, we're talking about lawfully owned firearms. And in this country, the Supreme Court has just said, hasn't it, Seema, that you have a right to bear those arms in your home.
But in this case,
interesting question that I think is key in this case about premeditation. And Joanna, I'm going to come to you on this. Premeditation can be formed in an instant, right? And if you're holding a firearm, you can premeditate murder and then carry that out. Whereas if you have some more elaborate plan, like poison or even theoretically a knife, it requires more action. So this distinction between I just snapped and premeditation under the law, it's a very fine distinction.
Well, actually, in this case, the way that they used the word premeditation, how it applied in this specific case, was that the type of gun that he used, it took that he had to actually click it back. It's not like I'm trying to show anyone how to use a gun. Click it back, not that I know well, but click it back and then to reload and to have the gun. So the fact that there was a time factor in order to use the bullets, that time factor they actually translated into premeditation.
And that helps the prosecution's case
all
in a
day,
different kind
every
of case.
Day.
Right, and in a different kind of case with a different kind of weapon, the defense might have a stronger argument. Very, very interesting. Premeditation can be formed in an instant. Okay, right now we want to get you.
Sometime due to heavy rains and a storm some weeks ago, a couple months ago, it's possible that relevant evidence has spread over a big area. And it may not have been the case, of course, had the remains just stayed in a dry spot. So that may be part of the reason why it's taking so long. Jamie?
All right, let's bring our guests into the conversation, Beth. We have Joanna Greenwald, Seema Iyer, Kurt Flehinger, all criminal defense attorneys. And let me begin by asking about the effect of this finding. If it turns out to, in fact, be Caylee Anthony, what impact will it have on the case? Joanna, first to you.
Well, the whole face of the case literally has changed. We've discussed, and I've discussed with you actually several times, that in the past it's been, for the most part, a purely circumstantial case that they were trying to gather evidence more and more, taking their time under the gun, if you will, politically, to try to get as much as they could to make this case. But then to charge for murder, which it took them a long time to do, but they were under a guideline where they had to do something, they never had a body. To find a body, all of a sudden, now the whole thing, the whole facet of what this case is about, changes. And if it turns out that this body is, in fact, Caylee Anthony, well, now we have a whole different story of what's going on. And I think what's very important to know is the reason that they're taking their time is that because everything being submerged, you're looking for every piece of evidence known to mankind. The reason the defense is filing this motion, they want to be there and be watching everything, is they have a similar case. They're looking for something, and it's a legal term of art that you're looking at, for spoliation of evidence. There's only a certain amount of DNA that you can gather from tissue, from hair samples, from whatever they find, because being underwater helped preserve the situation, but also hurt the situation.
Yes.
So as a defense attorney, I want to be watching everything that you're doing because I want to have my chance with my specialists to be attacking what you're doing.
Beth Karas, you reported earlier, and I'm going to bring Seema and Kurt in just a moment, but be present. Joanna, let me come to you on the question of the jury pool. As Beth has reported, this is front page news every day, pretty much since last summer. There's not a person in Florida, and I would bet in the country, that hasn't heard about this case. How do you get a fair trial? Even a change of venue probably isn't going to help you, right?
Well, you'll always have people, as we saw in recent cases of people who are famous people. There are people in a jury pool that will say that they can be impartial. And that we have to believe, as defense attorneys, we have to believe that when people say that they can be impartial, I agree with you. They're going to I don't think they have any alternative but to do a change of venue, because it's literally on every newspaper, every magazine, every station is covering this, because when anything happens to a child, forget about a woman, a man, children are put on a pedestal. This is something that everybody's going to know about, and you have to be able to find people who are impartial, and you have to believe in the system. Just like you said, you being on the side of presumed innocent and having the cloak, the shield of innocence, you have to believe in that. That too, you have to believe that you could find a jury who believes in being impartial.
Yeah, it puts a lot of pressure on the judge. I never envy judges, but I really don't envy the judge in this case. Seema Iyer, I'm tight on time, but I do have to ask you about this issue of fairness in court, given the
That's not going to happen until a final identification of the remains.
All right. Well, Beth, you will stay put and keep us honest as that goes down. With that, the best defense will rest for the day. Big thank you to a terrific team. Seema Iyer, Joanna Greenwald, Kurt Flanger. Fun to spar with you today, and Beth Karras, as always, for her fine reporting. Let's check in with Ashley Banfield. Somebody mentioned Canada before for a look at what's coming up next.